Good morning. My name is Gary Resch. I'm an attorney with Below Vetter, and I'm here with my colleague, attorney Alana Leffler, also Below Vetter. We're here today to talk about seclusion and restraint, the new law in Wisconsin that actually went into effect last March, but kind of got lost a little bit in the shuffle as a result of COVID-19. So we're going to talk about it today, both the basic requirements, but highlighting those things that are different from the old law. And I guess we'd like to start with an executive summary and basically explain why the changes that were made are important and why the law is important. First of all, the issue of when children are secluded or restrained is of great concern to parents. Parents obviously get very concerned when their children engage in conduct that would cause school officials to need to seclude them or restrain them. And as a result, the law that was effective March 4th of this year expands and kind of institutes best practices of how to implement and then provide other rights to parents and procedures for school officials. So the law explains the definitions of what is seclusion and restraint, what the notice requirements are to parents and other staff, what prevention strategies that we might implement to avoid having to engage in seclusion and restraint, what restrictions there are on the use of seclusion and restraint, what training we should engage in with our staff, and then finally, what monitoring should be engaged in by both us and actually the state government, DPI, and the federal government as well. So the law goes through all of those things, and Alana and I will kind of hit the highlights, but the PowerPoint slides themselves kind of go through a lot of them. But a couple other things as to why this is important and why it's important both to implement the law and why the law's best practices are so helpful to us. The use of seclusion and restraint has constitutional implications as well. There are substantive due process concerns. There are also seizure concerns under the Fourth Amendment, substantive due process under the 14th Amendment. So implementing 118.305, our statute, protects us because it implements appropriate procedures for us to follow so we don't run afoul of any of the constitutional requirements. Another issue that makes this law particularly important is that of equity. One of the things in analyzing statistics that the Department of Education has found is that children with IEPs and 504 plans and students of color are disproportionately subject to seclusion and restraint compared to their makeup of the student population. So in looking at the equity concerns of the use of seclusion and restraint, following those best practices will help us as well. We're also going to talk about special challenges of implementing the law, especially during this time period of COVID-19. So when we go through the particulars of the law, and then at the very end, Alana and I will kind of click off some things to remember during the COVID-19 pandemic that will assist us in better implementing the law. And then finally, we would be remiss if we didn't suggest that you look at DPI resources. They've got some up-to-date resources on explaining the law, giving you ideas for training and options for training as well. So go to the DPI website and have a look. So the executive summary begins on this slide. As I mentioned before, the new law is effective March 4th, 2020. We were out of school then, right? So from a practical standpoint, we weren't overly concerned about having to implement it. So now students in many of our school districts are back at school and we have to pay attention. And Alana and I will talk about the things that need to be in place immediately. Other new parts of the law that we just wanted to highlight right at the beginning is there are greater obligations on private schools when public schools place children under the IDEA and under Chapter 118.15, the statutory sections are listed there. Also of great significance, and Alana and I will talk about that later, is the fact that law enforcement officers, and primarily our SROs, are going to be involved in the procedures, both, as a follow-up and the reporting to the parents when we engage in seclusion or restraint in school. So keep in mind, even though they're not a covered official under the definitions of the law, a covered individual, they are subject to some of the procedural requirements. And Alana will talk later about the definitions as they've been clarified as well. Continuing, the law that went into effect on March 4th prohibits the use of rooms or areas which have locks. The follow-up procedures have been augmented, and Alana will talk about those in quite a bit of detail. The annual reporting has been, I think people would say, simplified, clarified, and the timelines made easier to follow, and those are listed on the outline as well. And then Alana will talk about how the procedures relating to children with IEPs, and you could use those same procedures for children with 504 plans, harmonize better the requirements of this law with IDEA placement and IEP and FAPE procedures. So I think when Alana goes through those, you'll see that they make more sense. And then lastly, incredibly important, is the content training was changed. And of course, we need to get our people trained and up to speed as soon as possible now, if you haven't done that already. And the content we'll see when we talk about what's old and what's new is substantially different. I think, Alana, some basic definitions.
I told myself I'd remember to unmute every time. Hi, everyone. Thanks, Gary. Yes, I'm going to go through some basic definitions now that you'll find right in the statute and we'll be, talking about for the rest of this presentation. There's a very specific definition of what is seclusion and what is restraint right in the statute. And first, we're going to talk about seclusion. Seclusion is the involuntary confinement of a student apart from other students in a room or area from which the pupil is physically prevented from leaving. So that's what seclusion is. And in order for us to properly do seclusion, the type of seclusion that's permitted under this seclusion and restraint statute, we have to meet all these conditions listed on this slide. They all must be present. So the first one is kind of what is leading up to our decision to seclude a student. The student's behavior has to present a clear, present, and imminent risk to the physical safety of that pupil or others. It also has to be the least restrictive intervention feasible. So that is something that, we should document, and I know we'll get into the reporting obligations in a minute, but we should be able to articulate that and document it so down the road, if our practices are being challenged, we are able to explain this was the clear, present, imminent risk to the physical, safety of that student or others, and be able to articulate why we had to resort to seclusion and there wasn't a lesser restrictive intervention that would have eliminated that safety risk. The second bullet point, a covered individual, and I'll get to that definition in a minute, has to maintain constant supervision of the pupil, either by remaining in that room where the student is secluded or by observing the student through a window that allows the covered individual, which would be, one of our staff members, to see the pupil at all times. And there's a number of reasons for that. As you can imagine, one of the biggest ones is for safety reasons, just to make sure that the student is safe, although they're being confined in a room and prohibited from leaving. The third point, that room or area in which the pupil is secluded has to be free of objects or fixtures that may injure the pupil. So typically this is something we want to plan for in advance and have seclusion spaces that are going to fit that criteria. I know in emergency situations, sometimes we use the rooms we have, and someone should just be trained, in these requirements so that they can remove anything from the room that we have to before secluding the student. And then next, the duration of the seclusion can only be as long as necessary to resolve the clear, present, and imminent risk to the physical safety of the pupil or others. So when that risk is eliminated or alleviated, let's say the students calm down, they're no longer a danger to themselves or others, then we should stop the seclusion. And still, there might be other measures we take to continue to address the situation, but that's where we stop the seclusion. And then the last requirement, no door connecting the room or area in which the pupil is secluded can be capable of being locked or has a lock on it. So that again goes to where we are secluding the student and something we want to plan in advance for. So now physical restraint, what do we mean and what does the statute mean when we say restraint? That is any restriction that immobilizes or reduces the ability of a pupil to freely move his or her torso, arms, legs, or head. And later on in a couple of slides, Gary's going to mention what is not physical restraint. Certain like redirections or, very, touching a back to redirect. Gary will cover that. But that is what restraint is defined as, and it is really like we have had to get into an in-depth analysis sometimes looking back of like, okay, was the student immobilized? Could they still move arms or legs? I mean, that's something that we really do have to take a look at. And I know training should really get into what do different types of restraint look like, so staff is aware. Just like we talked about for seclusion, there are certain conditions for using restraint that have to be there in order for us to be permitted to use physical restraint on students. First bullet point is the same. There has to be that clear, present, and imminent risk to physical safety of that student or others, and it has to be the least restrictive intervention feasible. So we already talked about that. There also can't be any medical contradictions to its use. And then third, the degree of force used and the duration of the restraint can't exceed the degree and duration that are reasonable and necessary to resolve the clear, present, and imminent risk to the physical safety or people of others. So it just has to be, reasonable in scope, basically, similar to what we talked about with seclusion. The next slide talks about maneuvers or techniques that cannot be used in order for it to be permissible under the statute. And staff training should encompass these as well, because we need, our staff to be trained in what types of maneuvers to use. So just clicking through them in the outline, the first one, we can't use maneuvers or techniques that don't give adequate attention and care to protecting the student's head. Can't use techniques that cause chest compression by placing pressure or weight on the pupil's chest, lungs, sternum, diaphragm, back, or abdomen. And those that place pressure or weight on the pupil's neck or throat, obviously just, given national events, that's a very concerning one. On an artery or on the back of a pupil's head or neck that would otherwise obstruct the pupil's circulation or breathing, for those that place the pupil in a prone position. And then definition of a covered individual. Why this is important is, you'll be seeing this term in the statute and in our training, and it's defined as an individual who's employed by a governing body, so employed by the school district, or under contract with a governing body as an independent contractor to provide services for the benefit of the school governed by the governing body. So that's kind of a wordy definition, but I think the takeaway is that our staff would be covered. It could also cover people who, itinerant service providers who are in our schools, we're paying to provide a service. The other bullet points, an individual who's implied by a person under a contract with the governing body to provide services for the benefit of the school, an individual who's engaged in student teaching, those individuals are covered. And I will just mention, you'll notice that law enforcement officers aren't included in the definition of covered individuals, but as we'll talk about, and as Gary mentioned, these requirements and the procedures we'll be talking about still apply to law enforcement officers. I think why they're not included in this definition is there's certain parts of the statute that just talk about what training covered individuals would have to have, and that's, separate and apart from what training law enforcement might get. But the statute will note when it's covered individuals and law enforcement officers are subject to certain requirements, and we'll talk about that more in a minute. Oh, Gary, you're muted. Let's just both stay unmuted.
Perfect. Thank you. Thank you, Alana. Before we get into more of the details as to what procedures are required, we wanted to highlight some of the definitional changes. So there's a lot more definitions in the statute, but these are the ones that are different from where they were before. And we've both talked about how a law enforcement official is now included in the procedures of the law if they use seclusion or physical restraint, even though they're not a covered individual. And here's why that's important. One is an SRO, or a law enforcement officer, is often operating under the school district's direction and control, and therefore the school district can be liable for the conduct of the officer under certain circumstances. So having them being familiar with the requirements of the law, their obligations under the law, and the process by which school officials are going to implement and follow up the use of seclusion and restraint is important. So as you start talking to your SROs and local law enforcement agencies about their law enforcement officers, deputy sheriffs, police officers that come into the schools, or the SROs, for which the school districts are often having contracts with cities and counties, we want to keep in mind that we should look to those contracts to see what appropriate updating may be helpful at this point to ensure that both the law enforcement agencies are aware of obligations under the law, and then secondly, we work in harmony with them. The second definition about determining whether there's a singular or multiple incident is important for two reasons. One is there was a lot of concern about whether the reporting to the DPI was consistent among school districts as far as the number of incidents that occurred, where it wasn't always clear whether it was a series of events constituted one incident of seclusion or restraint, or two or three. And so this definitional section is designed to address it. So let's go through it and highlight the important part. An incident is singular, not multiple, if immediately following the use of seclusion or physical restraint on a pupil, the pupil's behavior presents a clear, present, and imminent risk to the physical safety of the pupil or others, and a covered individual or a law enforcement officer resumes the use of seclusion or physical restraint. So notice there's basically two breakpoints here. One is immediate, so that the incident is counted as one time of seclusion or restraint. If one component immediately follows the other, and then secondly, notice what the last conjunctive says, and a covered individual or law enforcement officer resumes, the key word being resume. So you have conduct, physical restraint, let's say, then the definition implies that there's a let up or release, and then immediately following, another incident or a continued incident occurred where the officer or covered individual resumes the use of seclusion or restraint. Now, obviously, these are going to be case-by-case determinations, but as I said, it's important for consistency of reporting, and then secondly, the process we have to follow, right? Because Alana's going to talk about the follow-up, both for children with IEPs and 504 plans, as well as all other students. And if you have 2 or 3 incidents versus 1 incident, you'll see that the process can get awfully involved and different under those circumstances. Notice the definition of the prohibition of mechanical restraint that I think Alana alluded to earlier, addressed 2 areas that were unclear before, and the statute now has made clear, that mechanical restraint does not include the use of supportive equipment to properly align a student's body, assist a student to maintain balance, or assist a student's mobility under the direction and oversight of appropriate medical or therapeutic staff. So you can see that we'd have a situation, a student with an IEP, a mobility issue, a different sort of physical or mental impairment that probably is under basically the rubric of an IEP or a 504 plan or a related medical plan. And then the second one, we actually have gotten a lot of questions on this over the years, that the use of vehicle safety restraints when used as intended during the transport of a student in a moving vehicle, so in a bus, where students to maintain a safe transportation, that does not constitute a mechanical restraint under the prohibition of the law. Excuse me. This would be an edit, I hope. The statute also adds a definition of parents, whereas Alana will be able to explain later, it's important as to with whom the report is shared and contact is made when a use of seclusion and restraint occurs. So that definition and change is very helpful. Some other additional clarifications, and Alana alluded to these earlier, they basically harmonize other types of things we normally do that typically then or under the law would not be covered under 118.305. So the new law does not prohibit covered individuals from the following, and those are listed: directing a pupil who is disruptive to temporarily separate himself or herself from the general activity in the classroom to allow the pupil to regain behavioral control and the covered individual to maintain or regain classroom order. And that may be just stepping to another location. It's not the same as physical restraint or seclusion that would be anticipated by the statute. It's simply taking the child to another area of the school where they can calm down and relax, often by an IEP or a 504 plan. Second bullet point, directing a pupil to temporarily remain in the classroom to complete tasks while other pupils participate in activities outside the classroom, really just the opposite of the first one, and that's where everyone else is removed. The student is maintained in the classroom, but they're not restrained or secluded in any way. It's simply removing the other children. And then finally, and this is the one Alana specifically mentioned, briefly touching or holding a student's hand, arm, or shoulder or back to calm, comfort, or redirect the student. We put a reference to our corporal punishment prohibition statute. As you'll recall, the corporal punishment statute also excludes incidental touching of the type described here as not being a part of the prohibition against corporal punishment. And so those are helpful. We actually had questions on all of those over the last year. So this is a great help in the statute. Some additional changes before Alana talks about school procedures that are used following implementation. And we've listed the new requirements, and Alana mentioned a couple of these before. And the reason we're mentioning them again is they're so important. So as we go from section to section of the requirements, you'll see the new parts, so that will help you update your own knowledge, but training as to perhaps what has changed. So Alana already talked about how rooms or areas can't have a lock or be capable of being locked. We are prohibited from using the prone position for restraint. And then a covered individual who has not received training may only use physical restraint on a student at school in an emergency, and if a covered individual who is received training is not immediately available due to the nature of the emergency. So keep that in mind, and obviously that goes to the scope of the people that we will have trained in school. But the bottom line, of course, is we have to maintain a safe and orderly school environment. So notice then that we still have the ability to maintain that environment, but we should make every effort, if we have to restrain a student or seclude them, that we're using appropriately trained people. And when we talk about training later, we'll see why that's so important. Alana.
All right, so now we're going to review school procedures that we have to follow following the use of seclusion or physical restraint. So these are really important. I can't tell you, we're going to talk about reporting obligations, and there's different timelines based on what requirement we're talking about. I'd say it's important, maybe your school can develop like a seclusion and restraint checklist for, okay, if it's used, here's like check the box, follow those requirements for reporting obligations, just to make it easy for your staff to comply with these requirements. Because this is something parents will pay attention to, and especially parent advocates and attorneys will pay attention to. I've been involved in a lot of situations, and Gary has as well, where once a parent gets an attorney, they'll ask for a log of these types of reports that we may or may not have, but hopefully have. So school procedures following the use of seclusion or physical restraint. When a covered individual or law enforcement officer uses seclusion or physical restraint on a student at school, the school principal or his or her designee shall do all of the following. So the first one, as soon as practicable, but no later than 1 business day, so it's a quick turnaround, after the incident, we have to notify the student's parent of the incident and of the availability of a written report, which is the next one. So the report might not be available yet, but we're going to, let the parent know that this occurred and that a report will be available for their inspection and review. And then just circle back to Gary's definition before that he mentioned of who is a parent. Within 2 business days after the incident and after consulting with covered individuals, any law enforcement officers present during the incident, we have to prepare a written report that contains all of the information on this slide. So the student's name, the date, time, duration of the use of seclusion or restraint. So we need to make sure our people know to keep track of that information, obviously. A description of the incident, including a description of the actions of the pupil before, during, and after the incident. So I think that will go to, what was the use of seclusion or restraint justified? We will describe that clear, present, imminent threat that led up to the use of seclusion and restraint. And I think the student's behavior during the incident also goes to how long are we using seclusion or restraint, and what types of techniques are we using? Are they the least restrictive feasible? And then we also have to include the names, titles of the covered individuals and any law enforcement officers present during the incident. A couple things I'd say about that report, and I guess about all of the reporting obligations or procedural requirements following the use of seclusion and restraint. Obviously, we want to comply with those reporting obligations and the timelines in the statute, but there are times that we've found that a timeline wasn't met for one reason or another. And I think whenever we find a procedural error like that, we want to fix it. I know that sounds common sense, but sometimes we found people are hesitant to send out a report, 2 weeks after the fact, because I think that will draw attention to the fact that they didn't do it within the timeline of the statute. But it's always better to fix an error when you find it. So please advise your staff of that as well. And one other quick tip, we've had situations where we don't believe something was seclusion or restraint, but let's say a parent or their attorney believes it was and says, why didn't we get notified? Why didn't we get access to the report that's in the statute? So sometimes what we'll do, either to be proactive because it's a close call, or in response to a parent's request or their attorney's request, is provide some type of document, whether it's in letter format or another format, saying this incident occurred, here's what we did, we don't believe it was seclusion or restraint for these reasons, but we wanted to let you know. So that's something to keep in mind as well. So back to the slides, school procedures following the use of seclusion and restraint. These are more procedures we follow. We have to meet with the covered individuals who participated in the incident to discuss all of the following. So it's kind of a debrief session where we're going to talk about what events led up to the use of restraint, what occurred during the use of restraint or seclusion, and then what happened following the use of the seclusion or restraint. And then also we want to talk about how to prevent the need for seclusion or restraint, such as different de-escalation techniques, possible interventions, other strategies that the school principal or designee determines are appropriate. And then the school principal or designee has to retain a report prepared under A, so that report we just talked about, within 3 business days of the incident, so another timeline to keep in mind, has to do one of the following: either send the report to the student's parent by first class mail or by electronic transmission, or hand deliver the report to the student's parent. So sometimes that will be done if there's going to be an in-person meeting with the parent or an IEP meeting, which we'll talk about in a minute. It can be hand delivered instead. Now we're going to talk about students with disabilities, students with IEPs specifically. So the requirements we talked about just now apply to any use of seclusion or restraint for any student, not just students with disabilities. Although, as Gary pointed out earlier, there is a disparity in the use of seclusion restraint, and a high percentage of the students it's used on are students with disabilities. So there are some special requirements we have to follow for students with IEPs. And I know there's a lot in this slide to unpack, so I'll spend a bit of time on it, but there's certain procedural requirements that are triggered the second time that seclusion or restraint is used on a child with a disability with an IEP within that same school year. The IEP team has to convene consistent with, we cited, or the statute cites, Chapter 115, which sets out procedural requirements for IEP team meetings and IEP team procedural requirements. So the IEP team has to get back together as soon as practicable after the incident, but no later than 10 school days after the incident. So another timeline to put on our checklist. The IEP team has to review the IEP and revise it as the team determines necessary to ensure all of the following. One, we want to make sure that the IEP includes appropriate positive behavioral interventions and supports and other strategies to address that behavior of concern. It's kind of that, proactive approach. How do we minimize the chance that we'll need to use seclusion and restraint again? We also need to ensure that the interventions, supports, and other strategies included in the IEP related to the behavior that resulted in the use of seclusion or restraint are based on a functional behavioral assessment of that behavior. So make sure the team is looking at whether an FBA has been done, and if it has been done, whether it has actually assessed that behavior that led to the seclusion or restraint. And if there has been an FBA, but it didn't look at that behavior specifically, we want to get another FBA done. So we really are making informed, data-driven decisions about what to put in the BIP or what positive behavioral interventions and supports to put in the IEP to lessen the likelihood we'll need to use seclusion and restraint again. And that's another thing I'll just quick mention. If we found that the IEP team, perhaps there was a procedural error, they didn't meet within the timeline, which we're certainly recommending that you do follow the requirements and meet within the timelines. That's another thing, just make sure we fix any procedural errors, get the team back together as soon as we discover that there might have been a procedural error.
Great,
right.
Thank you.
Yeah.
Oh, great, thank you, Alana. Boy, if I were a principal now, I would take a deep breath. I was listening to Alana's discussion of the procedures that have to be followed once seclusion and restraint is implemented, and notice 2 things of interest. One, it was principals or designee. So if I'm a principal, I'm thinking about when there are difficult times in school and a lot is going on, even if I don't think at the beginning of the school year a designee might be necessary, it probably is helpful to arrange for 1 or more designees so that when things get busy and a principal has other things that need to be done, there'll be people trained and maybe someone that you have taken with you through the process so that they'll be there to step in. And then secondly, the students with IEPs. Do you notice if it's the principal that is kind of coordinating what occurred, how did it happen, prepared the report, talked with everyone, the principal or the principal's designee is probably a key person at the IEP team meeting or 504 meeting as well, so that from a practical standpoint, the part that Alana just went through are those things that are probably at the heart of this law. And so everything else just kind of revolves around it. And so staff training, we've listed on this next slide the new things that are required by the law that hadn't been in the old statute. And notice what's interesting about all three bullet points. Evidence-based instruction techniques to assist basically school officials in understanding what occurred, de-escalate, prevention, reduce. Basically what the statute is designed in its training editions is for school officials to help determine ways to extinguish or replace the inappropriate behavior that leads to seclusion and restraint. And providing training and evidence-based training assists us in that regard. And then notice the third requirement, we just included it here, that basically the trainee has to demonstrate his or her ability to identify prohibited techniques in administering physical restraint. That's so that when we go through all the training, the law, as we talked about before, has specifically defined what's appropriate, what's not appropriate, and what's not appropriate. We need to ensure that our people are properly trained. The additional training requirements come from the old law, and we've listed them. My guess is that all of your people that are covered individuals have already been trained in this regard. Notice, though, that we've just referenced the private school training requirements. Keep that in mind, and if I didn't mention it earlier, I don't recall, look at your contracts with the private schools, make sure there's good communication so that you're confident that if you place a student in a private school that they're going to follow the requirements of the law. You know, whether or not our school district would be liable for something that occurs in a private school is a case-by-case determination, but we just want to be clear about that so that they understand their obligations under the law. And then secondly, the second bullet point on this slide, a record of the training. That is so important, and it's one of those things, you know, Alana talked about earlier, if we make a mistake, correct it. I think what you want to do now is as we start the training for the new law or look back on the training you might have done this summer in your staff or in services, make sure we have a listing of who was trained and how they were trained. The next bullet point talks about then the additional training requirements that were in the old law, and we talked about those earlier as well. And the training, as I said, you can look to DPI for resources, but a lot of the training is going to be on content by properly trained people that can assist you in training on appropriate methods of physical restraint. The last couple of points on the outline, we'd like to briefly talk about the United States Department of Education and federal implications, many of which Alana has already talked about, but just wanted to mention that the U.S. Department of Education has quite a bit of guidance. They have 15 principles on the use of seclusion and restraint. And I think it's fair to say that if we follow our Wisconsin law, we're going to meet the requirements of federal law as well. So that's another reason to follow the requirements of 118.305, so that if we would get a complaint to OSEP or an OCR complaint, we're going to find that we're in compliance of those 15 principles that are listed in the document that we've cited in the first bullet point. And basically that's what's explained. The harmony between the two is that our state law embodies those principles. Alana's already talked about guidance from the IDEA and just wanted to, I guess, second what she said as to the appropriateness and why it's important to follow the procedures of 118.305. As we've talked about, the IDEA in Section 504 don't expressly prohibit the use of seclusion and restraint, but it can affect the provision of FAPE. So as Alana said, you basically want to do an FBA. The BIP, or the special factors section of an IEP, is going to address then positive methods that we would use in interventions to address misbehavior as a way of inhibiting incidents that would lead to seclusion and restraint. And then, of course, as I said before, in order to provide a free, appropriate public education, we're going to attempt to reduce or substitute. Basically, we're going to want to eliminate or replace, extinguish inappropriate behavior. Section 504, both Alana and I have talked about it, is implicated where we have disparate or different treatment between children protected by Section 504, those with IEPs and with 504 plans. So keep in mind that, as both Alana and I have said, the statistics show that there's a disproportionate amount of use of restraint and seclusion on students protected by Section 504 and the IDEA. How do we address that? Look at our criteria, policies, and practices. Make sure the training is up to speed so that when we're implementing seclusion and restraint, we know that we've taken all the steps to ensure that really it's necessary, that we've tried to prevent, we've tried to address the antecedents that lead to the inappropriate behavior, et cetera, et cetera. And then the last bullet point under Section 504 talks about child find implications, because if we have children that are not currently with IEPs or 504 plans who engage in behavior that leads to seclusion and restraint, one should just consider whether or not there might be a reasonable belief that a child does have a disability under the IDEA or Section 504. Other legal concerns and constitutional issues, and C with capital C in Constitution. I mentioned earlier the 14th Amendment and the Substantive Due Process Clause, and then the seizure prohibition under, remember, search and seizure under the 4th Amendment. Not going to go into them now, other than to say that it's important to remember Section 504, the IDEA, the 14th Amendment, the 4th Amendment, and then the ADA Title II, which basically duplicates to a large degree Section 504. The reason that that's important is it could lead to a federal claim if we violate someone's rights. So it's not only a state law issue, but it becomes a federal law issue as well. The final topic today, we would be remiss if we didn't mention it. And for those of you watching it after the COVID-19 pandemic, that's a good thing. So you probably can hit stop right now. But for those of us that are still in the COVID-19 pandemic, here's some things to remember. That we had schools closed between March and June 30th, right? So that we had a lot of students who weren't in school, whose routines were disrupted. So they're going to come back to school in many cases. And for a lot of children, that's going to affect their behavior. So we have to remember there's a greater likelihood of the types of misbehavior that could lead to the use of seclusion and restraint, especially among students with 504 plans and IEPs. So what do? Well, one of the things we would do is train staff and I guess redouble our efforts to address de-escalation and transition strategies for these students. And for a lot of children, I think our staff has been communicating with parents and talked about ways to address the return to school, but look at transition plans and strategies so that maybe we can avoid an uptick in the behavior that would lead to the use of seclusion and restraint. Review IEPs, and as Alana said, determine whether or not BIPs need to be updated or we need to do FBAs to address situations. And this is where an ounce of prevention makes a lot of sense, because as the DPI guidance is made clear, in determining whether we have to have additional services based upon the end of last year's school closings, and then secondly, whether or not we should have contingency plans depending upon the mode of instruction that we're using or might pivot back and forth from. We're going to be reviewing a lot of IEPs anyway, so it makes sense for those children that have had challenging behaviors to address the FBAs, BIPs, and IEPs. And then lastly, it's been a huge topic, but basically the use of personal protection devices can substantially affect how children behave in school. And there's going to be a certain group of students where the use of face coverings, for example, are going to increase the level of challenging behaviors. And probably what a lot of our staff has done already is communicated with families, have had students start to wear PPDs at home, face coverings, etc., so they'll be used to it when they come to school, but keep in mind that that may be an issue as well. And the last other issue that I will mention under COVID-19 is the whole issue of safe implementation of seclusion and restraint. Check with your local health department as to how people that are engaged in seclusion and restraint do that safely, and do that under the COVID-19 environment in which we're in. I will now defer to Alana to see if there's anything I missed or you'd like to add, and wish everyone well and a thank you from us.
I don't have anything to add. I guess my only thing I'd reiterate is something you mentioned. I know that it's a lot, especially the procedural requirements and timelines. And these often are kind of those emergency situations. So I think just making some kind of checklist that simplifies it in some ways where you feel comfortable that you're doing everything we just talked about and everything's in the law, and you'll feel great with every box you check off. So I'd encourage you guys to do that. And just like Gary said, we wish you well in the upcoming school year. I know this is going to be a difficult one. So good luck, and you're all doing a great job. I can assure you, no matter when you're watching this, you're doing a great job.
So have a great day, and thank you very much.